Hello friends, Namaskaram. Myself is Dr. Janesh Soni. I am an advocate and a corporate lawyer. Today in the present class we will discuss the voice sample and importance of voice sample in the anti-corruption case. Do you know when the accused is caught red-handed or there is a case that accused demanded undue advantage, in that scenario he is charged as per section 7 of PC Act. As we know that to constitute the offence, demand is must. It is called sine qua non, means must. If demand is not proved, even though there is recovery or acceptance, the accused could not be convicted, even prosecuted. Demand is must for prosecution, as observed by Honorable Supreme Court in Neeraj Datta versus State of NCT. But the primary question arises whether the accused is bound to give voice sample. What are the legal provisions? Who can take voice sample? And what we should do in case we are having a notice concerning voice sample. The concerned queries are answered in the present content. I request all of you to maintain a proper notebook with pen or pencil so that you could update your information or knowledge in recorded format. First of all, we have to consider the basis of voice sample. Basically, we are having a scientific method which is called voice spectroscopy. It is basically a science wherein the alleged voice, that is called disputed voice, is compared with the specimen voice, so that on the basis of data comparison, analysis could be done and result could be ascertained in term whether the alleged voice belongs to the person or not. The same is also considered one of the most important method to ascertain the disputed voice. But sometimes it is seen that the result of voice spectroscopy is not optimum. As the method is scientific, there is a possibility of error. In that scenario, serious prejudice might be caused to the rights of the concerned accused. So we have to understand the basis so that whenever we are going to give voice sample, we could know about our rights and their duties. The important judgment concerning the voice sample is propounded by Honorable Supreme Court in case of Sudhir Chaudhary versus State of NCT. Judgment is pronounced on 29th of July 2016. Certain guidelines are propounded in favor of accused. How to take voice sample, how to prepare the transcript, by whom it will be prepared, and apart from that, it is emphasized that when the accused is directed to give a voice sample, it would not infringe Article 20 subclause 3 of Constitution of India. But we have to understand that the right to life and liberty are the fundamental rights, and no one is allowed to infringe the same without adopting a due process. And that's why the prime point is that the authorities are bound to follow the judgment of Honorable Supreme Court titled as Sudhir Chaudhary versus State of NCT concerning the concept of taking the voice sample. If they are not following the precedent or the protocols in that scenario, we may challenge the proceeding as per law. Apart from that, we must understand that there was no provision in CRPC regarding the voice sample. Even Honorable Supreme Court, in its one of the most important judgment, specified that there is no specific provision in CRPC taking the voice sample. But in that judgment, it is specified that until and unless the Parliament specify the provision, the magistrate may direct taking of voice sample. The judgment is titled as Ritesh Sinha versus State of UP. That is most important judgment on the subject, and judgment is pronounced by Honorable Supreme Court on 2nd of August 2019. If you will peruse the entire judgment, you will get that in para number 12 it is specified that none of the amendment specifically authorize or empower a magistrate to direct an accused or any other person to give his or her voice sample. And apart from that, in the last paragraph, it is specified that in the light of above discussed, we take the view that until explicit provisions are engrafted in CRPC by the Parliament, a judicial magistrate must be conceded the power to order a person to give sample of his voice for the purpose of investigation of a crime. Such power has to be conferred on a magistrate by the process of judicial interpretation and in exercise of jurisdiction vested in this court under Article 142 of the Constitution of India. But right now we are not having CRPC in motion. Right now we are having BNSS. As per section 349 of B.N.S.S, certain protocols are made to take voice sample. So we have to understand the condition precedent for taking voice sample. The primary condition is that in the title word magistrate is used, which is clear that the police or CBI or vigilance or ACB could not take a voice sample without the permission of magistrate. Because at the inception the term used is the power of magistrate to order a person to give voice sample. Although the word voice sample is not used in the title, but the word signature or handwriting etc. is used. And in the explanation clause, the word voice sample is used. Now we are going to study the legal protocol, which says that if a magistrate of the first class is satisfied that for the purpose of investigation or proceeding under BNSS, it is expedient to direct any person including an accused person. Means the primary condition is the satisfaction of the magistrate. And if the said scenario is required, in that scenario, while passing the order, the magistrate is required to record reasons. If reasons are not recorded in that scenario, the order would be illegal, and apart from that, the magistrate is bound to hear both the parties before passing such order, because no order as per law can be passed without hearing the opposite party or the party against whom an adverse order is passed. So if the ground of satisfaction which is required by Honorable Supreme Court verdict titled as Inderjit Singh versus Santosh are not complied with, and apart from that, the concerned party or both the parties are not heard, in that scenario there would be infringement of principle of natural justice. In that scenario, the order could be challenged. And apart from that, it includes person, means a witness or complainant, in addition to accused. In that scenario, he may direct the concerned persons to give specimen signature or handwriting or voice sample. He may make an order to that effect, and in that case, the person to whom the order relate shall be produced or shall attend at the time and place specified in such order and shall give his specimen signature or finger impression or handwriting or voice sample. So the primary part says that the satisfaction of magistrate is required. Apart from that, while passing the order as per the rule of judicial interpretation, he is bound to hear both the parties. But once the order is pronounced, in that scenario, the concerned person to whom it is directed, he shall attend the proceeding to give voice sample. What shall is used means if the order is done and you fail to give voice sample, in that scenario, adverse inference is drawn as per section 119 of Bharatiya Suraksha Sanhita, then the accused would be responsible for the same. So before giving voice sample, we have to ensure the grounds of satisfaction. Number 2, whether the concerned accused is heard or not. And apart from that, what protocols are duly followed by magistrate while directing the accused to give his voice sample. If the important parameters are not followed, and it is observed that the guidelines of Honorable Supreme Court judgment titled as Ram Singh versus Ram Singh, citation is 1986 EIR Supreme Court, page number 3, and Sudhir Chaudhary versus State of NCT, as discussed by me, are not followed in that scenario, the proceeding would be illegal abuse of process. To be noted that sometimes it is seen that only CBI or vigilance or ACB give the notice, and entirely it is compelled that you should give the voice sample, you may refuse, because still the police is not having any power to compel you to give the voice sample. Apart from that, we are having one of the negative scenario, which is inter alia incorporated in the form of proviso. The proviso attached to section 349 of B.N.S.S says, no order under this section shall be made unless the person has at some time been arrested in connection with such investigation or proceeding. Means if the person is not arrested during the course of investigation or proceeding, the concerned accused cannot be compelled to give sample of his voice. The direction can be given if he is arrested in connection with investigation or proceeding. But second proviso is in favor of prosecution. It says that the magistrate may, for the reasons to be recorded in writing, order any person, means witness, complainant or accused, to give specimen or sample without him being arrested. So if he is not arrested, even though if the circumstances appearing on the file inter alia point out that it is expedient that the voice sample is to be directed, in that scenario, the magistrate may direct the voice sampling, but for that he has to record the reason. So in nutshell, we could say that the voice sampling provisions are incorporated in section 349 of B.N.S.S. The magistrate may direct for voice sampling. The police cannot compel you for voice sampling. If the police is compelling you, there is no order of magistrate, then you may refuse. But if the magistrate orders and there is no satisfaction, apart from that there is non-compliance of principle of natural justice, and even the reasons are not recorded, you may challenge the impugn order. And apart from that, you have to see the legal compliances of guidelines propounded by Honorable Supreme Court concerning voice sample. So these are important guidelines for your understanding concerning the voice sample in anti-corruption cases. Apart from that, you have to note that when you are charge sheeted, you are entitled to get the clone copy of the alleged electronic file. If the same is not given, you may file the objection. And even you are having a right to get the opinion of private expert. That is called cyber audit. Sometimes it is seen that with the help of AI tool, the voice is created. Or sometimes the voice is inter alia dubbed or created or modified. And apart from that, the instrumentations might show error and they are not appropriate as per section 63, subclause 4 of Bharatiya Nagarik Suraksha Sanhita. So, in light of legal protocol, you may raise the objection to secure your rights from being vanished. If the present content appeals to you to be appropriate, then I request again maintain the proper notebook and inter alia update the information in recorded format accordingly, and further request all of you to share this content so that your colleagues, your clients, and apart from that, those who are indulged in the said problem may get a little solution. See you in the next video. Till then, Jai Hind, Jai Bharat.